Good afternoon, everyone, and thank you for joining us for the Greater Reading Chamber Alliance Labor Law Update. My name is Katie Hetherington-Cunfer, and I'm the Director of Government and Community Relations for GRCA. So that you're aware, we'll be recording this presentation and sending to anyone who registered to participate, and you'll all get a copy after we're done today. We're pleased to be able to offer our members this chance to talk about all emerging issues in the field of labor and employment law with Kevin Moore, partner and chair of Barley Snyder's Law Labor Practice Team. Kevin is a graduate of Shippensburg University, and he earned his law degree from Widener University School of Law. He is involved with clients at many levels, working with them broadly as general counsel, as well as other areas such as commercial and construction litigation, and is heavily engaged in GRCA's Human Relations Roundtable. Kevin's a past chair of the Berks County Bar Association Employment Law Section and is a member of the Pennsylvania Bar Association Employment and Labor Committee. In his spare time, he volunteers as an attorney as a volunteer solicitor for many community and charitable organizations. He's also a very active volunteer with the Boy Scouts of America and the I Am Able Foundation. He sits on numerous school and church-related boards and committees and resides in Spring Township with his family. We asked Kevin to give an overview of all the recent changes in labor and employment law, including the U.S. Supreme Court cases of Groff v. DeJoy, Students for Fair Admission versus Harvard, and other state and federal regulations that are in the pipeline, and what your company can and should do to enhance policies and procedures. Once Kevin's presentation is concluded, we'll open up the chat for Q&A. So as you have questions as we're going along, please put in your questions, but we'll wait to do questions at the end to give Kevin a chance to go through everything. I will read the questions, and if we don't get to questions that are asked today, we'll make sure to include that in a follow-up email with a copy of this recording. So hopefully we'll be able to handle everything. Kevin and I were joking before we came on that we have an hour, so we'll solve all the world's problems in 1 hour today. I personally invited Kevin, if you have not had the opportunity to work with him on stuff, I appreciate his take on things and his candor and his sense of humor. So it makes labor law fun. So that's why I like to work with Kevin. So I'll turn the comms over to you, Kevin. He's got a bit of a presentation, and looking forward to hearing what's going on. Tell everybody where and when to worry and when to not worry, and hopefully we'll get through some of the good stuff. So turn it over, Kevin, and we'll see what you got.
Okay, Katie, thank you very much. Thank you everyone for jumping on today. I know we're all very busy, and hopefully you got a little bit of caffeine in you after lunch and you'll stick with us for the next hour. One correction on our content today. I won't be covering Students for Fair Admissions versus Harvard. I simply don't have the time in our agenda. That is an affirmative action case involving college admissions. If anyone here is from Albright, Alvernia, Penn State, Kutztown, wherever else, we can talk offline. Simply cannot fit it in because there's so much more to cover today and more relevant to all of you who are on here today. Okay, so let's get right to it. I've got a pretty substantial set of content here, and I can't even get to all of the cases that are new because it's been an active year in labor and employment law. Some of you may have been at my good friend Andrew Howe's presentation yesterday. Our state commission, the Human Relations Commission, which enforces our state anti-discrimination statute, promulgated a set of regulations to clarify and expand the definition of race, of gender, and of religious creed. And I've cited the codified version that went into effect just a few weeks ago. And I want the real takeaway here. The important part of this is these definitions, at least interpretation, came through case law expansion, not amendments to the statute. It's just not something that the legislature gets involved with a whole lot. They probably should. But state and federal courts have interpreted the act to expand the definition to cover all these versions of sexual orientation and gender identity. What was most compelling to me when I read the regulation was here at the bottom on race. It talks about race now includes, traits historically associated with race. I'm not sure whose standard, of history applies here, but it talks about hair texture, protective hairstyles, and then there's a catch-all, any other national origin or ancestry as specified by a complainant in a complaint. Now, you know, the content of the regulation and the reports that came out when it was being promulgated was, we're just codifying what the existing law says. Well, that's not what happened. They went a little further, okay? And so we all need to be aware that the Commonwealth, the Human Relations Commission, will now be considering whatever any complainant identifies as a characteristic historically associated with their race. That leaves the door open to increased litigation and a further expansion of the definition through case law. So don't be surprised if you see a PHRA claim nestled in there with an EEOC charge, and there's a brand new category that you hadn't heard of before. The regulation allows it. All right, so this just is the expanded definitions of both religious creed and sex, and as you can see, it identifies all of the broader interpretations that the courts have already adopted as it relates to the rights under the act. So the takeaway there for state law action is simply that there could be complainant subjective new definitions or characteristics that heretofore an employer didn't know might not have known were historically associated with race. So we just have to be aware of that as an employer. Okay, can we go to slide number 4, which I think already. Okay, slide number 4, and Jen, you're just gonna have to chirp and say something like, okay, that you're there.
Yep, okay.
Okay, so slide 4 is the takeaway. What I've done here in the format for today is discuss a case and then followed by a screen or a content about the employer takeaway. And I've already addressed that. And I'm already 15 minutes into my presentation and way behind. So let's go to the next slide.
Okay.
Okay, Groff versus DeJoy. This was the Postal Service carrier case. This would involve the accommodation of someone's sincerely held religious beliefs. This was a well-publicized case. It came out of Reading. Our sitting federal judge, Jeffrey Schmale, ruled on the case. And we had a rural carrier refuse to make required deliveries on Sundays and took his sincerely held religious belief. The employer made certain efforts to accommodate transfers, switching off, mandatory overtime, etc. And he ultimately was discharged and he filed his claim. Next slide.
Okay, with the takeaway?
No, it should be slide number 6, prior precedent.
Okay, yes.
Okay, so the Supreme Court, both Judge Schmale, the district court level, and the Third Circuit Court of Appeals upheld the dismissal of this employee's claim, and but the U.S. Supreme Court took the opportunity to clarify what we have long called the de minimis hardship test. So very similar to the ADA reasonable accommodation standard. That's the analytical rubric which the court stepped through, but we had some prior precedent that talked about and referred to the phrase de minimis, that the standard on an employer to prove undue hardship, which exists, was just much less. And this really represents sort of a correcting of the standard. But what the court didn't do, and in fact expressly rejected the EEOC's definition. The EEOC had requested that the court adopt the ADA standard for undue hardship, and the court wasn't willing to go that far. So they've come up with a test that is abrogated. It got rid of the de minimis test, but it's we're calling it the substantial cost tests. So let's go to the next slide. And slide number 7, it talks about undue hardship now is shown when the burden is substantial in the overall context of the employer's business. So it's a very fact-specific inquiry. Courts have to take into account all relevant factors, including the type of the accommodation, its practical impact, depending on the size, the nature, and operating costs. So it's not quite the ADA undue hardship standard. It's certainly leaning in that direction. So going forward, that case, by the way, has been remanded to Judge Smale for further proceedings to apply the new test. We don't know where that stands right now, but that's the standard by which we all should, govern ourselves. We don't have any new case law, generated since then. So stay tuned on that case, because as soon as we hear a decision, we'll be putting out a client alert. Okay, next slide.
Okay. Slide 8.
Slide 8. Okay, this is a case that I happened to get involved with and wrote a client alert for our firm a little while ago. And this is a different spin on, religious beliefs. And this involves a state of Colorado anti-discrimination law and, the conflict that you run into with First Amendment free speech rights to express religious beliefs. Okay. And this was a pretty well advertised case, or well known. A web designer wanted to expand her web design business to wedding announcements and creating wedding announcement websites. But she had sincerely held religious beliefs that on the topic of same-sex marriage. She knew that the Colorado law existed. So in a unique procedural move, and she had some legal help with various organizations, she filed a preemptive request for an injunction. And she wanted to have the court rule that if she were to put a notice on her website that she would not provide these services for, that violate her beliefs on same-sex marriage wedding announcements, that she would not be prosecuted, for a violation of the act. So the case ended up being ruled on what's called a stipulated record. Both sides basically stipulated to the facts. And one thing that got stipulated to that I think perhaps the state of Colorado might be regretting was this, the notion that the creation of a website, a wedding announcement website, is expressive activity and not anything less. So that was stipulated too. Okay, next slide. And so on the next slide, number 9, the federal court in Colorado rejected her case, upheld the law. The 10th Circuit Court of Appeals affirmed the district court, further upholding the law. The United States Supreme Court looked at it differently. And, we had, since the last decision, we have a firm conservative majority on the court, and that was noted by every possible commentator. But in this case, the court held that website design represents the designer's own expression, and therefore is expressive speech under the First Amendment. And the conclusion was a person whose business is open to the public cannot be compelled by state action, that being the anti-discrimination law, to be forced into creating works of art, expressive activity that violates their sincerely held religious beliefs. And let me I actually have a copy of the decision in front of me here somewhere. The court basically said that, we're pitting what we call the compelling public interest. Whenever you're passing laws that affect free speech, the state has to have a higher burden, a compelling interest. And the compelling interest is in preventing discrimination. This was based upon sexual orientation, but that's in conflict with the individual's protected right to free expression of sincerely held religious beliefs. The court concluded this, and I'm quoting Judge, I think it was Judge Neil Borish. Yeah. Quote, no public accommodation law is immune from the demands of the Constitution. When the public accommodation law sweeps too broadly to compel speech so that the two collide, there can be no question which must prevail. The First Amendment. That was a pretty broad stroke there. There was a vigorous dissent by Justices Sotomayor, Kagan, and Jackson, And what you need to know as a takeaway, and let's go to the next slide. Okay.
There you go.
Perceived as a victory for free speech, a victory for religious liberty in commerce, those who are in the business of, being open to the public. And the court here did not have to reach that determination of what exactly is expressive activity. That was left alone because it was a stipulated fact at the lower court level. That's going to be a case-by-case analysis going forward. So keep your eyes open for that particular topic. But it's not a blanket protection. Even the court said it's not a blanket protection, for those who engage in commerce to utilize it as a basis for protected characteristic or protected class discrimination. So we're going to see a lot of activity on that. I think, as I read just the other day, there's a case coming up through the circuit courts in North Carolina, and it was a Catholic school teacher who was got married, same-sex marriage, and under the North Carolina anti-discrimination statute, the teacher could not be terminated for their beliefs. And in light of the 303 Creative LLC case, the representatives of it was a Catholic high school, went back in and have now appealed, and that's going up on the strength of that case. So we're going to see more litigation. It's already happening. We're all going to have to just keep our eyes open. And remember, this was a business open to the public. Doesn't apply to everyone, but you just need to be aware that it is out there and it's the law of the land. Okay, next slide.
Slide 11.
Yes, slide 11. The DOL, we have more activity on the moving target of independent contractor status. And, those of you who have been to my seminars in the past know we have a multitude of tests. We have the DOL FLSA test, we have the NLRA test, we have the IRS test, we have the PAUC test. Depending on which law you're evaluating, the test is slightly different. And in October, the DOL said, okay, we're going to change the rule. We're going to overturn the Trump era definition and go back to the Obama era definition. We're going to do, proposed rulemaking, follow the process, etc. That final rule is expected to come out, and it's going to reinstate what we used to call the totality of the circumstances test. Ironically, the DOL, I identified the fact sheet. I don't have the link hyperlinked here, but the DOL was criticized because it went ahead and put out the fact sheet on this rule, even though it's not technically the law of the land right now. But if you want to know, what's coming, and it may get litigated, probably certain to get litigated because of what's going on, but that's in fact sheet number 13. And we're gonna touch on this in the NLRB piece as well. Okay, next slide. Okay, so it's almost 2 o'clock, and I've gotten through a variety of what I'll call the regular employment litigation stuff. The balance of this presentation is really going to rely on, or going to focus on, what's going on in labor law. And again, you don't have to be a union employer to be subject to this law. You've heard me say this time and time again, but the statistics continue to grow. Just a little bit of statistical notions here. So union election filings for elections have increased 16% from 2022, which was a 53% increase over 2021. Biggest numbers since, I think one statistic showed me, since 1995. The fiscal year for the NLRB is October to October. So from October of 22 to halfway through 2023, the unions have won 80% of the elections that have been held. And I pulled up some data. I didn't share it today, but there are elections in every conceivable part of our economy, from restaurants, hospitality, to healthcare facilities, to libraries, to museums, to academic institutions. It's all over the place. There is no part of our economy that is immune from this trend. And it's a trend driven by high-profile cases. We all know what those are. So no one is immune from the process. The NLRB, just like the EEOC, likes to advertise, how much they've recovered, 51 million in all forms of damages, penalties, costs, back pay, all sorts of things, big fat numbers to scare everyone. What I noticed here, which is important to see, is this. The average time period for petition to elections, 37 days. That's, lower than the maximum under the statute right now. We're going to see that at the end of this presentation that those rules are going to get even further compressed. But right now, if you have a union petition, you're looking at finishing your election process in, just a little over 5 weeks. That's real fast. Okay, and going to get faster. Okay, next slide. All right, I'm on 13.
Correct.
Perfect. All right. What I'm doing now is this, and again, if you are on my client alerts, you have seen I've been very busy this year with NLRB action, particularly, and I'm just going to go through it by month because, and I'm skipping a whole host of cases. Let's go back to February. McLaren-Macomb was the NLRB decision that threw out severance agreements between an employer and furloughed union employees. The employer made a knucklehead mistake by permanently furloughing employees, giving them severance packages, and completely ignoring and bypassing the union. This is obviously a subject of what is called effects bargaining, and the union has to be involved. So if that weren't bad enough, and certainly the employer, lost that part of the case, but the board went further and they took the opportunity, as you will see from the entire year of Biden administration decisions, they're taking the opportunity to either revert back to the Obama era or going further. And that's what we need to be concerned about. It's not a surprise that there's a seesaw here between presidential administrations, but the board in this particular instance, and what we'll see, has made a couple of extra new rules. Okay. So what did they do? They said these non-disclosure and non-disparagement provisions of a severance agreement are facially unlawful. That's one part. That's one disqualifying effect. But then the board went further and said the mere act of offering the severance containing the provisions is in and of itself unlawful because it has this reasonable tendency to interfere with Section 7 rights. Quickie primer. That's the right of employees to engage in what we call concerted and protected activity, to discuss terms and conditions of employment. Okay, and that theme is gonna run through these. Okay. Now, there's a whole bunch of elements of McLaren-Macomb that we have to discuss. Not only did they take issue with those two provisions, but then they went further and said, you know what? Not only does Section 7, have protection for these issues to discuss terms and conditions with your coworkers, it protects former employees. That was a big issue in this case because these employees were severed. They were already out of work and not employed there anymore when they were offered the separation agreements. But the board didn't care. It also protects them to communicate. And the communication channels can include the public, can include social media, print media, political, judicial, legislative forums. I mean, pretty much just tossing out the idea that confidentiality can be maintained through a separation agreement. Both the employer appealed. They took a very long time to do it, which was troublesome to me. And the union petitioned to enforce the order. So it's up in front of the Sixth Circuit on cross appeals. And what we need to know is that your severance agreements have to be more carefully looked at, particularly if certainly if there's a bargaining unit involved, and B, even if there's not a bargaining unit involved, because the law applies to everyone, you don't know whether someone on the other side of this transaction is talking to someone who knows the NLRA, knows the NLRB. I've shared in prior audiences that I had a case with a non-union employer. Employee was offered a separation agreement in conjunction with their termination, and the employer got sued for discrimination. So an EEOC charge got filed, and the employee's lawyer was savvy enough to know that they could file a separate charge with the National Labor Relations Act. And I was the unlucky party who was told by the Philadelphia region that we're going to use your case as a test case. And we're coming after you for your handbook and the separation agreement that you offered that was unlawful. Lucky for us, two things happened. The investigator took family leave till next January, and the NLRB is really hurting for staff and budgeting. So no one substituted for this person, and the case is very quiet. Okay, next slide. Slide 15.
14.
Oh, 14? Whoops. Okay, I covered 14. We can go to 15.
Okay, 15.
Sorry.
It's okay.
So
On
15,
yeah.
now we have the GC memos. They don't have the force of law, but they tell us where the prosecution is going with prosecuting cases. And the general counsel, Jennifer Abruzzo, is the most active and assertive and progressive of general counsels in a long, long time, and really pushing hard to advance the administration's agenda, before the board. So she issued a GC memo following McLaren-McComb and took even greater steps to discuss these clauses. And she talks about how, well, if you have a non-disparagement clause, we're going to tell you it's got to be really narrow. Okay. And essentially, folks, where we've gone from non-disparagement, which is don't say bad things about us if we're going to settle with you, to now, don't defame us. And malicious falsehoods is, effectively the defamation standard, a very, very high bar. And she also says we don't want to be involved with any the scope creep where you're expanding this to every division, every affiliate, every parent, every subsidiary. It needs to be limited to the employer of record, or else we're gonna take the position that it's invalid and facially unlawful. Okay, next slide. She also took the chance to go after non-competition clauses that show up in separation agreements or settlement agreements, for that matter. One thing that came out of McLaren-McComb is the scope. So McLaren-McComb's case dealt with a separation agreement, severance agreements, but the board said we're gonna apply these standards to any employer communications. Well, that's certainly very broad. And we see that here with non-solicitation clauses, non-admission clauses, cooperation clauses, all the things that you folks rely on your lawyers to tell you, this is important, this needs to go in. Well, in light of this, we're now, having to deal with it. Let's go to the next slide. 17.
Yep.
Now we have to take a close look at it. We have to ask ourselves, do we absolutely need this language to achieve the material terms of whatever our agreement is? I've talked with lots of my partners and other colleagues in the profession. You folks didn't dream this stuff up, right? You came to lawyers, and there's very good reasons we put all this stuff in. Now, in light of the fact that we can get investigated and prosecuted and have a whole host of separation agreements declared invalid, we have to be more careful. Okay, so you're going to have these looked at. A year ago, in the last 2 years, we talked about savings clauses, they're disclaimers, Section 7 disclaimers. And you've all heard, okay, well, what do we do here? Well, what if we put a clause in that says, nothing in this document shall be interpreted to, interfere with the employee's exercise of Section 7 rights under the NLRA. The NLR board general counsel said, I don't care. I don't care if it's there. That's no insurance against us declaring it invalid. As an attorney, I still want it in there, and I think you should all have it in all of your important documents just to be safe going forward. Even offer letters could be implicated in this. And one other item that I didn't mention, it's not in the materials, but in that memo, in light of McLaren-McComb, the general counsel in her memo said, we think you should go out to every party, every employee who has one of these invalid agreements, notify them that it's invalid, and let them know that they're not bound by it. That's a GC memo. It's not the force of law. McLaren-McComb is on appeal, and I've advised my clients that I don't believe it's in their best interest to conduct that kind of outreach. Others may disagree with me, but we're not doing that. The breadth and scope of some of these memos is astonishing in how far away they are from the actual decisions that are being handed down by the board. It's as if this GC is running so fast ahead of case law, it's just not waiting. Okay, another case, Noah's Ark processors, and this is April, so we're moving forward from February, March, April. Just a quick note on this one. Historically, remedies for unfair labor practices for many, many, many years, for decades on end, were reinstatement, back pay, okay? In late 2022, a case called Thrive Inc., the board expanded the definition and now says that the remedy can apply to all direct and foreseeable harms, including out-of-pocket expenses, credit card debt, tax implications of a recovery. These are things that those of us who defend employment cases often see in generic discrimination matters. Now we're seeing it applied in the NLRA context, and that's going to drive up the cost and the value of these cases. So we have to be aware. The Noah's Ark case went even further in April, and the Noah's Ark case ordered the employer to pay the union's legal fees in the collective bargaining process because there were a bunch of ULPs filed during collective bargaining. There was a finding that the employer engaged in bad faith bargaining, and they got hammered. You can imagine, you spend months and months negotiating a contract. Yes, it might get heated, and the employer got tagged with having to pick up the union's legal bill for the entire process, not just for the conduct that was the alleged bad faith. They're going to creatively expand the remedies. They're going to press the envelope. We as employers have to be aware of that. Okay, next.
Slide 19.
Yes. So Lion elastomers. Now we're in the month of May, and some of you may have seen this on media. Employee outbursts can be found to be protected concerted activity, even if they're expletive, salacious comments that are violent in nature and violate, any number of workplace conduct rules that are in place by the employer. If the employee, can prove that they were engaged in Section 7 activity, okay? It's a very different test. It was a setting-specific test. We do not have the time, folks, for me to get into this in greater detail because the decision was very, very detailed. But the Trump-era standard, this is an overruling of a Trump-era case going back to the Obama standard, which was, quote-unquote, setting-specific. So if you're dealing with it, you have to identify the subset. Is this a managerial confrontation? Is this involve picket line conduct, or is it social media or another? That's the first level of analysis. before you take action against an employee. And again, this doesn't have to be the guy wearing the union t-shirt. This can be anyone. This law applies to union and non-union workplaces alike. And that decision, expanded the scope, or brought it and expanded the scope of the conduct and reinstated the old test. Okay, next slide, slide 20, the Atlanta Opera. Okay, this is where now the board is taking board action through decisions to clarify the independent contractor test under the NLRA. Okay, the board held that makeup and wig artists, hairstylists were in fact employees, not independent contractors. And this overruled a Trump era decision, so it hadn't been in place only since 2019. But instead of, the board said we're resorting to the common law agency test. That's not really true. In fact, they've added 2 elements that they want to see addressed that could have inferentially been addressed in prior decisions during the Obama era, but made it clear that now you have to ask, is that person who we're talking about, are they rendering services on behalf of an independent business? Well, think about that. If it's skilled labor like the stylists, they're probably out on their own, right? Is there an independent business? Probably not. So that's a problem. Second, the question that gets asked is the employer constraining the person from pursuing other business opportunities? If they're truly an independent contractor, are we preventing them in some way from, doing hair and makeup for some other theater or another show production, et cetera? That's now the test. So I'm calling that common law plus. And we need to be aware of that should it come up. And I'll explain why there's a should it come up. Next page is the takeaway. Okay. Why is this important? Well, independent contractors don't get to vote in union elections if you can survive the test. If they're employees and they're in the proper unit, they're going to be included in the vote. Okay. The gig economy, the fracture of traditional employment relationships, all of these things have increased the use of independent contractors, not decreased them. But we all have to examine that both presently and prospectively. When I mean prospectively, you've got staffing requirements for your companies. You may be seasonal, you may be seeing layoffs coming, whatever it may be. And it is a very natural and appropriate, consideration for an employer to say, should I sub this out, whatever the service might be? Certainly an appropriate decision. You have to also look through it through this lens and be aware of it. Classification problems are very, very common across all areas of our economy, and you just need to be aware of it. Okay, next slide. All right, I have 215. Yeah, Stericycle.
Yep.
Okay, Stericycle, national company with local facility in Morgantown, and I think a facility down in Souderton, Montgomery County. Okay, this was sort of the buffet attack on handbooks, and here the employer's handbook rules had a whole bunch of work rules challenged: the cell phone rule, personal conduct rule, the conflict of interest, you name it. And case first goes to administrative law judge. The administrative law judge, without getting into detail, found some were, facially valid, and others were facially overbroad and therefore invalid. And the board on appeal said, you know what, we're going to announce a new test. Okay, so this is where the board has created a new test. It's not just overruling and going back to an Obama era standard. So let's take a close look here. The general counsel, that is the board, just has to prove that a work rule has a reasonable tendency to chill the exercise of Section 7 rights. Okay, that's fairly low bar for them to come over, right? And then we have this new test of what's the context. The finder of fact has to put themselves in the place of, and if I were in English class in 7th grade, I would use like a language arts diagram. reasonable employee, okay, who is subject to the rule and who is, this is the new test, economically dependent upon employer, okay, and who is considering exercising Section 7 rights, not necessarily actually exercising them, okay? So multi-point test, and that's a challenge, okay? That makes it very easy for them to prove. If they prove that, okay, that an employee could, now look at this, could reasonably interpret the rule to have a chilling effect on Section 7 rights, then the rule is presumptively unlawful. So we're having board action shifting burdens here. Okay, next slide.
Okay.
Now we have a new test, a new burden on the employer. You've got to prove your rule advances some legitimate and substantial business interest and compound, meaning both elements have to be proven. You are unable to advance that interest with a more narrowly tailored rule. I had a big problem with this decision when it came out because we have rules already in place, and now you're asking us to defend the existing rule and now prove something we never had to prove before. That we filtered it through this, is there a more narrowly tailored rule test? It is a unwinnable argument. You need to be aware of it. That's going to happen as part of these prosecutions and as part of these new enforcement actions that are coming out of the regions. Okay. Next slide gets us to the election rule. Slide 24. Are we there?
Mm-hmm. Yes.
Okay, great. Okay, in the last week of August, I put something out. The board issued 6 or 7 decisions and came out with rules, either a decision or published a rule in the last week of August. And it was I think a Labor Day present for organized labor. And I can't touch upon all of them. I'm just going to touch upon the 2 most important ones. So what has been called the quickie or ambush election rule of the Obama era has been reinstated, and with some extras. So this is a overruling reinstatement plus rule. And there are a lot of elements having to do with employer shortening the timeframes for reporting, shortening the timeframes for submittals, giving very little leeway to the employer. This is all designed to make the election happen much quicker and put more burden on the employer. Now, this particular rule, interestingly enough, was part of what is called direct rulemaking. There was no notice, no opportunity for public comment. And so they're jamming this one down our throats. And it goes into effect December 26th. Because it reinstates mostly a prior version, I would expect that it will survive. It'll survive court challenges. So we have to be ready by Christmas for this new rule. And the takeaways is you got even more compressed schedule. I told you under the existing rule, the average is 37 days. Under the new rule, it's probably going to be down to 25 average. There's some leeway in there that has to do with the extensions, but boy, that's a 4-week election schedule, and that's very, very fast. Okay, next slide. Okay, Cremex Construction Materials. This case was decided on August 25th, just a few weeks ago, and there's another flipping of the burden going on here for issuing remedial bargaining orders. Okay, historically, you didn't have to bargain with a union, even if they showed you the cards, unless and until you completed your election. Okay, that was the rule of law for 50 years. And remedial bargaining orders, which are an extreme measure, which says we don't care what you think, we're ordering you to come to the table, very rarely used and only in the most egregious, outrageous, pervasive, unfair labor practices. Well, now it's being used as a weapon. So here, the board held that any unfair labor practice by an employer during what they call the critical period between the petition for the election and the election itself is sufficient in and of itself to set aside the election, regardless of its results, and result in a direct remedial bargaining order. That is harsh. Next slide. This is where it really hurts. The burden has now been flipped. So consider this. If the union shows up and shows you the requisite necessity, which is really 30% or more of signatures of the pool, that's enough to get the petition filed. Now, if they have that and they show you that requisite showing of support, you either start bargaining now by recognizing the union, or now you, the employer, have to file your own election petition to challenge the sufficiency of support, okay? Because technically speaking, they're only showing you 30%, and they're going to need a majority, right? So you have to file it, but let's read it really closely. That election has to be held within 2 weeks of the showing of the signature cards. Wow. I mean, you're going to stop everything you're doing to get this done. The third option, which is really not an option, is don't do either and immediately face an unfair labor practice charge for failing to bargain in good faith, which of course we know from the board, they're going to conclude, yes, that's true. And they're going to give you the bargaining, a remedial bargaining order. So what it's doing is it's taking the burden off labor to ask for the election and to lobby for the election and have the democratic process of the union election. Instead, it's just taking that off the table. If they've got 30%, they're forcing the ball into your court, and you've got to act really, really quickly. I cannot impress upon you enough, how important this is. And I believe that this has already been appealed, but there's no activity on it, and I don't know if they've sought a stay of this particular order. I'll be following up on that shortly, but this one really flips the script when it comes to elections. So you companion this with the compressed schedule, and that's a full court press by the National Labor Relations Board. Okay, I know I talked really fast about these topics, and you all have the content. It'll be available. I think I got to the Q&A. Unfortunately, folks, because of my technology deficiencies, I can't see if there are any questions. So, Kate, if you're out there, can you tell me if there's any questions? And if not, I welcome anyone's questions on anything I covered or anything that's on your mind. We have another 5 minutes to talk.
So not a problem, Kevin. No, appreciate all the information you gave us. I mean, so if anybody has questions, please put them into the chat feature. My takeaway from your presentation is there is a lot of things kind of going on right now, and I know it's a lot to take in. So, for a lot of our folks that are participating, what can they do? What steps can they take? Recommendations on, how to keep track of some of this, how to make sure you're keeping your policy books up to date. What are some suggestions?
Okay, so your documentation, your handbooks and your agreements need to get looked at in light of all of these decisions because of this overbreadth, facially unlawful set of decisions that are going to get you sued and prosecuted by the National Labor Relations Board. So documentation has to be audited. And we all hate to do this, one more handbook audit that we have to go through. This one is the scariest one I've seen in my career with all of this activity. Separately, and this really goes to organizing, and there may be union employers out there in the audience today. There may be those who respectfully choose not to be union and remain non-union. It is imperative for them to be agile and to have a plan. At Barley Snyder, here's my commercial. We have a rapid response plan module that we advise employers on how to combat union organizing and get ahead of the process. You're all great employers and you treat your employees, very fairly. If you didn't, you wouldn't be in business anyway. But you need to prioritize this process because We can't solve it with appeals and litigation. You're going to have to put the boots on the ground here and be prepared to deal with organizing. As I mentioned at the outset, it's affecting every segment of our economy. I don't even have to go into, whether or not unions represent less than 10% of the private sector or not. Throw those statistics away, because your employees, and it doesn't matter if they're the worst educated, low-level hourly worker or they've got a college degree. The organizers up at the Amazon warehouse in Staten Island were college graduates with bachelor's degrees who were working there, and they organized and won an election. So it could be anyone who organizes. That's my takeaway. Look at your documents, have them reviewed by a qualified labor attorney, and be prepared to deal with union organizing.
And so I would make the assumption that everybody on here has policy documents and has paperwork, but if you're trying to get started, or you're trying to maybe bolster what you have, what are some suggestions? Where can people get some of the resources they would need to start building this for themselves?
Well, obviously talk to your attorneys. Our firm has a handbook which we publish through the chamber, through the Alliance, and that's a sort of a primer document to get you started. But those of you who are members of SHRM, there are good forms available. If you can get forms that are compliant with Pennsylvania law, I'm not going to tell you not to do it, but please, have your documents looked at by attorney before you put them into effect. I'm dealing with an independent contractor classification problem right now for a local employer who has employees in almost all 50 states, and they didn't do anything the right way. And we're now going to have to make changes to literally 50 form contracts. So you don't want to incur that expense either.
And so I know we discussed a couple cases. What are some of the other things kind of upcoming that you're seeing? I mean, as I'm reading some of these cases, there's a lot of stuff where it's like, wow, I wasn't expecting that decision. Is there some other stuff that's on your radar that you're watching that folks should be aware of? Well,
we're seeing, we're seeing an increase in the religious accommodation for the sincerely held religious beliefs. We're seeing more of that. We're seeing a lot more medical marijuana. I didn't get into any case law on medical marijuana because I could spend a whole session on that. And that's a complicated affair in and of itself, because of the conflict between state and federal law, and depending on what kind of employer you are. We're seeing plenty of that. But look, the internet can be a dangerous thing, and people see things on the internet. They make allegations. We're seeing a lot of the social media related stuff, getting, terminations happening. And then if you have a charge under the act, and the person was engaging in what is called Section 7 activity, and the employer doesn't even know what Section 7 is. So obviously social media activity continues to be a part of all of our cases, whether it be as evidence or it's the main thrust of the case. So, you have the right to monitor employees' conduct at work, and make sure that you're being fair about that, because if you're letting them engage in personal use of devices, personal use of systems, make sure you're regulating that in a fair and even-handed manner. That's coming up more and more for us. Again, I could go on, Kate. I better stop.
No. This is the kind of thing where everybody's looking at this issue, but how do you? There's an influx, and so that's why I asked you to make this presentation. I know that there's a lot of information, but that's how getting a handle on some of this. I think that's some of the scary part for a lot of folks.
Yeah, and it's look, and those of us practitioners. I mean, I'm doing research on almost a daily basis to stay ahead of whatever's going on. And, I subscribe to a whole host of media, sources to gain my information, and I'm the one giving advice. Mm-hmm. It is nearly impossible. Those of you who are, again, SHRM members, they do a very nice job of staying on top of nationwide things. They've published a couple things for Pennsylvania just recently as well. So, you got to stay tuned and stay in touch. And don't be afraid to, pull us in. I always say this to my friends in HR, I'm HR's advocate, and sometimes the CEO doesn't like to see me. Sometimes they do, but we're here to help HR, help the business stay out of court.
All right. Well, I think that's a good message to kind of end on for this presentation. I wanted to get this information out there. I know this is probably a lot for folks to kind of have to run through their brains. So my hope is that there'll be some follow-up conversations and questions. But as there's information and stuff coming up, we will definitely keep everybody posted. I guess I brought Kevin on specifically because there is such a depth of knowledge, and this is changing at a consistent basis. And there'll probably be some more policies both at state and federal level that'll be of interest for everybody to keep track of. So this will not be this is not the final word on the subject, but we'll cap it for now, and we'll probably come back again soon to kind of give an even further update.
Yep.
All righty. Well, thank you everyone for joining us this afternoon, and we will send you a copy of the presentation once we've done with all the recording and downloading, and I'll get you a copy of the slides as well, so everybody has that in hand. Thanks so much.
Thank you.